Morning. Same. Okay, at this time, I'd like everyone to silence their cell phones and electronic devices. We'll be starting shortly. All right, thank you. Oh. All right. All persons having business before the Honorable Chief Judge and Associate Judges now presiding over the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and the Honorable Court. This Honorable Court now in session, please be seated and come to order.
All right, good morning and welcome to the District of Columbia Court of Appeals. I'm Anna Blackburn-Rigsby, and I'm joined by my colleagues this morning, Associate Judge Kate Easterly on my right and Associate Judge BJ Schenker on my left. We have two cases this morning. One of our cases is no longer going to be heard for argument today. The first case is Anthony False versus United States. Counsel, are you ready to proceed?
Yes. May it please the court, I'm Leslie Kostyshak on behalf of appellant Anthony False. I'd like to reserve 2 minutes for rebuttal. Innocent people plead guilty. Empirical data confirms this. Courts recognize this, and the Innocence Protection Act has codified this. The lower court rejected this premise, and its decision must be overturned for 3 reasons. First, the Superior Court denied due process in departing from the IPA's statutory framework, guided by its blanket belief that innocent people do not plead guilty.
Was that really the argument that you want to lead with on the Innocence Protection Act claim? There were some other factors in this case that seemed like they may have been compelling as well, but didn't seem to focus in on those issues.
Your Honor, I think all 3 reasons that we presented in our brief are compelling, and I'm happy to lead with whichever you prefer.
Well, just to jump in, I mean, the government, I think, makes the point that you don't actually challenge the trial court's determination that that your expert testimony failed to establish actual innocence. And so is that claim before us, or is your point that the consideration of the guilty plea overshadowed that? Or it's not clear to me.
Certainly, Your Honor. I think that the court's approach and consideration about the guilty plea and its failure to consider under the statutory framework the reasons that the defendant pleaded guilty as it was required to do colored all of its decisions in this case, including its assessment of the substantial evidence of actual innocence.
But counsel, I mean, the statute, you saying what the court did was contrary to the statute, it strikes me as being very consistent with the statute. I mean, the statute instructs that when you're dealing with a guilty plea as opposed to a jury verdict, courts have to take that extra step of asking why someone would claim actual innocence after having pled guilty. And that's the very question, perhaps inartfully worded, but that's the very question the court was asking. And to your point about the fact, I mean, I think we all can agree that innocent people plead guilty, unfortunately. And you know, the frequency of that is another question, but despite that, we operate in our system. We have to operate in our system with an understanding or an assumption or perhaps a legal fiction, whatever you want to call it, that when people plead guilty, they're pleading guilty because they did it. If we don't do that, trial judges can never accept guilty pleas. I mean, wouldn't you say that's true?
I agree certainly that we have to operate in the system. And I agree with you that the statute requires that the court consider the reasons a defendant pleaded guilty despite being actually innocent. I think if you look carefully at the order here, that was not done. There is a section of the order that is titled "The Reasons the Defendant Pled Guilty." If you read the 2 very short paragraphs that the court had in that order, it does not speak at all to the reasons that defendant here testified that he pled guilty. Anthony testified that he arrived on the morning of trial, found himself with a lawyer who was totally unprepared to defend his case and felt like his attorney had given up on him. So that culminated in him.
So, I mean, so I guess you're
hasty-
saying that the court didn't accept the answer, but it seemed like your briefing was that the court asked the wrong question. And those are 2 different arguments.
I think the court didn't analyze those reasons. When you look at the court's analysis, the court jumps straight to the guilty plea itself, and it doesn't look at what led up to that and the substantial evidence that was presented in the hearing as to why that decision was made.
What can I'm sorry, I wanted to see if we could focus on some of the other substantive reasons that you think Mr. Falls should prevail under the Innocence Protection Act?
Certainly. I think there was substantial evidence of innocence at the hearing. And once again, this is evidence that does not show up in the court's order. There's a huge chasm between the evidence that was presented over the course of the 3-day hearing and what the court actually looks at and grapples with in its order. For example, it's undisputed that multiple MPD police officers who were at the scene of this collision apprehended Anthony Falls coming out of the rear passenger seat of the vehicle. Those officers saw Darrell Ingram exit the driver's seat of the car and flee, after which Darrell was apprehended. It is undisputed. Both the government's expert and the defense expert agree that now, with probabilistic genotyping, which is a new type of DNA analysis that was not available at the original trial, both Anthony Falls and Darrell Ingram's DNA appear on the driver airbag. That is critical because at the time of trial, that DNA, the DNA of Anthony, was the only thing linking him to being the driver of the vehicle. And there's substantial evidence from an accident reconstruction expert who explains that because of the dynamics of the crash and the way the car would have rotated upon impact, how Anthony, as the rear seat passenger's DNA, could end up on the driver airbag. And that is,
I'm sorry, go ahead.
that is supported, the defense expert's theory about all of the passengers moving forward and to the left relative to the vehicle because of the rotation is supported by scene evidence. The back seat of the driver's seat is pushed forward from the rear passenger moving forward in the crash. And even Detective Miller, the government's expert, agreed that the rear seat passenger was thrown forward.
Well, this is where I sort of get stuck with the analysis because there are sort of compounded claims here before we get to the Innocence Protection Act claim. You have the 2 ineffective assistance of counsel claims, and they deal with whether the DNA evidence was effectively probed by trial counsel and by post-trial counsel, and claiming that neither of them successfully probed that evidence. But what difference would it have made if they had probed that evidence more closely at the time? If the new DNA testing that actually does show Mr. Falls and the originally thought to be driver Donnell's DNA on the airbag mean? In other words,
Certainly, I understand your question.
maybe I'm backing up too far in the analysis, but to make the arguments that you're making for the Innocence Protection Act, some of them depend on whether the expert testimony about the accident reenactment was properly admitted, whether there was ineffective assistance originally by failing to challenge the DNA evidence as it was known at the time, because there was a full report, even though counsel was told only Mr. Fals's DNA was on the airbag. So I guess, how do we analyze this? Do we start with the Innocence Protection Act and ignore the ineffective assistance of counsel, or do we need to establish that the expert testimony was properly admitted?
I think you can look at them independently and get to the correct result, but I agree that in many senses, this is all intertwined. Trial counsel was deficient for failing to investigate the DNA evidence. As I said earlier, that was the only evidence. That DNA of Anthony on the airbag was central to the government's theory. It was the only evidence that they had linking him to being the driver. And the trial counsel did not even consult with the DNA expert. Under Young and Kugosi, this is deficient.
Right, but I guess you just acknowledged earlier in your argument that the DNA testing that is available to us now was not available to you then. So it seems like your DNA argument is better housed in an IPA claim than an IAC claim because it only gets you so far as prejudice,
It
right?
is-
I mean, it might be deficient performance. Counsel should have asked somebody about the DNA evidence, but what would counsel have learned at that juncture? And so
It is correct that probabilistic genotyping was not available. There's testimony that there were other avenues that could have been explored as to the DNA at the time. For example, Stephen Mercer, who was qualified as an expert in DNA litigation, explained that there were multiple chain of custody issues that should have been explored.
But,
And
but
we're
you
not.
don't know, but,
More,
but you don't know what those, I mean, you're still not getting to prejudice then because you're completely speculating what those avenues would have shown, right?
well, there was testimony about what those potential avenues were. More importantly,
were.
as to the DNA, at the time of trial, it was known that there was a mixture of DNA on the airbag of at least 2 people. If that DNA evidence had been combined at trial with the accident reconstruction testimony explaining how Anthony's DNA could have gotten on the airbag, there would have been a significant chance that a jury could find reasonable doubt. And I think it's also important to talk about the government's accident reconstruction here. The theory of the government's accident reconstruction expert is that all the passengers were thrown straight forward and the driver and only the driver could have made contact with the driver airbag. That theory is completely inconsistent with the fact that a mixture of 2 people's DNA was found on the airbag.
Counsel, I think
So-
your theory strikes, I mean, I don't know if this is the forum to engage in accident reconstruction and none of us are physicists, but you mentioned inconsistency of the theories and it struck me that your theory, your client's theory is inconsistent too. If Mr. Donnell will, I'm sorry, I've forgotten the last name all of a sudden.
Ingram.
Ingram was in the driver's seat and everyone went forward and left, then how would his DNA have been on the right side of the airbag?
Our theory is not that he needed to miss the airbag completely. The government has misrepresented that over and over. It's simply that he would not necessarily have hit the center of the airbag. And the probabilistic genotyping does show that his DNA is on the side of the airbag. But going
which-
back to
I'm
the
sorry,
question-
which side? Because Judge Schenker said it's on the left side or on the right side.
Right side.
It's on the right side, but as explained in the evidentiary hearing, during a collision, the steering wheel is rotating. So there's no way of knowing which side is in which position at any point in a collision. All of this at trial, combined with the percipient eyewitness testimony of multiple MPD officers, would have created reasonable doubt.
But do you, I mean, this takes me back to the IPA claim. So you're saying, look, there's substantial evidence of innocence if you take what we already knew from the get-go, which is you've got 5 police officers saying that your client is coming out of the back of the car and that the driver runs and they apprehend him later. Plus the DNA mixture, which now can be identified as a mixture of your client and Darrell Ingram's DNA, plus the accident reconstruction. That gets you, all you need for an IPA claim is a preponderance of the evidence, right? To show that this evidence could establish actual innocence. So that's your claim, or because you were talking about beyond a reasonable doubt?
Yes, I was addressing your question about Strickland prejudice. And
Right,
what
but I'm
could have been
taking you back to
shown.
IPA. Sorry.
Yes, but
Yeah.
back to IPA, I think it absolutely shows by preponderance of the evidence that Anthony.
And then you're
could be innocent.
layering on the fact that the court considered the guilty plea and didn't consider your client's reasons for pleading, professed reasons for pleading guilty, just doesn't analyze them at all.
I think the order as a whole is lacking in analysis. In Caston versus United States, which was an IPA case, this court pointed out that the lower court had not grappled with the weaknesses in the government's case. The same is true here. As I mentioned, there was substantial evidence presented that is not even considered in the court's order.
And also part of the IPA claim is the admission of the accident reconstruction by the government some years later after the incident, after the crash. Is that correct? Or is that part of the IAC claim?
That's part of the IPA claim.
Okay.
And that testimony, the unreliable and speculative testimony, should have been kept out. It was an
Okay.
abuse of discretion.
And
to
your
allow it
argument
in.
is that that should have been subject to a Daubert Motorola analysis.
Yes,
Okay. And that's just not in the order, right? The
It's-
court declines.
the
to-
court gives very short shrift to the order, and there are two main problems with the Daubert analysis. Number one,
Well, did the court decide between Daubert and Dias?
no, the court never made this decision between the standards. I think the parties agree, no matter which standard you apply, the outcome should be the same.
Why would we apply Dias to a hearing that happened post Motorola?
It is our position that you should apply Daubert.
Okay.
However, whichever standard you apply, reliability matters. And that has been consistent pre-Daubert and post-Daubert.
So what does the court say about reliability about the reconstruction?
The court allowed the reconstruction to come in, and there are two pieces of its holding that were an abuse of discretion. First, the court based its decision to allow the unreliable testimony in on a misrepresentation by the government that the defense expert had also relied on the testimony. There's no support for that in the record. The defense expert testified that he did not rely on the Miller report because it was unreliable.
So the
Even
court just treated reliability as conceded? Is that your argument?
it did, and even putting that aside, there is a larger issue with the court's decision here. Let us assume for a moment that the court was not mistaken and all three experts relied on the Miller report. The court credits the two government experts for that reliance, while at the same time discrediting the defense expert. It does not explain the internal inconsistency, and it cannot be explained.
Did the court discredit the defense witness because it relied on the Miller
The court's-
evidence, or because it didn't find it as credible as the government expert that relied on the Miller evidence?
The court's order says that it discredits the defense expert because it relied on incomplete notes from 20 years ago. That is the Miller report that it is referring to.
So if I guess I'm still struggling with how to focus our analysis here on all these different claims. If the Innocence Protection Act claim relies on the claim that the government's expert reenactment testimony came in improperly, what's left there? Because the court did rely on that. Does that mean we have to then remand for a Daubert hearing on whether the expert testimony should have come in, which I think is the relief that the government is seeking? Or what is the relief that you're seeking? How we
I
address
think
this?
based on the errors that were made, you could grant a new trial under the IPA, or you could remand for a proper analysis of Strickland, Daubert, and the IPA.
So if we remanded, then we would focus more on the ineffective assistance of counsel claims of both trial counsel and of post-trial counsel.
certainly I think that would be a part of it. There's no question, first, that the lower court should have considered the ineffectiveness of trial counsel, but didn't. There is no analysis there,
And-
despite there being cause and prejudice to do so.
Is there a precedent on the claim that post-conviction counsel was ineffective also? In other words, I know we've said there's a right to effective trial counsel. And it seems logical that therefore that there should be a right to effective post-conviction counsel, but have we actually decided that issue?
I don't know that that's been necessarily decided in this context, but under Kyle v. United States, this court has held that if a 23-110 hearing is held and counsel is appointed, then it's statutorily required. And under the line of cases of McCrimmon v. United States, it would therefore follow that counsel would need to be effective. And if counsel was not, that would supply cause and prejudice for rehearing the 23-110.
If there are any other questions, I know you reserved time for rebuttal, and so we'll hear your rebuttal arguments after we hear from the government. Thank you.
May it please the court, David Sable on behalf of the United States.
Mhm.
The trial court did not abuse its discretion in denying the IPA claim below. First of all, we do understand, Judge Easterly, that the IPA claim is briefed as there was a legal error in applying the standard. And once you find that, then you get to the IPA claim. But we don't understand there to be briefed a freestanding IPA claim, looking at the court's findings, looking at the findings about actual innocence. That's the way I understand the brief. So, but if we do turn to that, first of all, the court found, well, it was undisputed that there was a large amount of DNA in the middle of the airbag. Yes, the only thing they knew in 2006 was that it was a mixture, but they also knew that the only other people in the car were excluded from that mixture. And that is a large amount in the middle of the airbag. The court also credited the government expert who said, it's just, and I don't really even understand this to be grounded in the total mapping. Chase said, look, the NHTSA standard is in a frontal collision, the airbag has to deploy before your face hits the steering wheel, because guess what? If it doesn't protect you. That's why the airbag deploys in 40 milliseconds before maximum engagement at 100 milliseconds. So if it's a frontal collision, you're gonna hit the airbag if you're the driver. That's what Chase said, and the court credited that. That's why the court found that to be convincing evidence. And the court said, look, Russell, over here, you're saying, oh, you're showing me a bunch of side impact collisions. I find that not persuasive. And remember, of course, it's their burden. And when the court was talking
When you
about,
say the court said that, the court doesn't say that in its order, right? Where are you saying that the court said that?
page 3 of the court's order, at the end of the first paragraph, defendant argues that this new DNA analysis, blah, blah, blah. This court disagrees, and then goes on to talk about missing the airbag entirely in the middle of the second graph. This court is unconvinced. Talks about the
Okay,
incomplete
it's just
note.
that paragraph.
I'm sorry?
It's just that paragraph
Are those
where the
two-
court says, I credit the government's expert. That it would
Right.
have been impossible. I mean, I guess what strikes me, right, like it's. I don't know how much testimony there was, but there's one paragraph of analysis on this, and there's no discussion about the fact that Darrell's DNA is on the airbag.
Well,
And that's the key, right? Because at the beginning, you have 5 police officers who are hot on the tail of this speeding car right before it hits. I can't remember the
So-
types of cars, but they, you have stipulated facts that the government stipulated to that the police are a block behind the car as it hits the other car. And just bear with me. And that they pull up, that they see the driver bail out and run, that Fultz comes out of the back seat and falls right outside of the back of the car because his hip is dislocated and he can't run. And they all say he's in the back seat and the driver is Darrell, right? And you know, I
Yeah.
know as well as you that eyewitnesses can be wrong.
Right.
But you know, you've got 5 eyewitnesses saying the same thing about where the driver went and who the driver was. And then the only reason that the government changes up its theory of the case and puts Mr. Fultz in the driver's seat is because they don't have any DNA from Darrell on the airbag. But lo and behold, there is DNA from Darrell on the airbag.
Yeah, it's consistent with touch DNA. It's not the large amount of DNA. But going back to the police
Possibly, but the
witnesses,
court doesn't say anything about that in its order, right? The court just says,
the court's
well,
not obliged to, Your Honor.
Miss,
It's not obliged to.
well, I mean, if we're trying to figure out if there's a preponderance of the evidence that, because it seems to me it could go both ways. If you've got both Darrell and Mr. Fultz's DNA on the airbag, both of them can't have been in the driver's seat. And I get that you're saying, well, more DNA from Mr. Fultz is on the airbag than Mr.
A lot more.
Darrell's. A lot more.
And so what you have is, well, I just want to say something about the cops first. There weren't numerous cops who saw Anthony Fultz get out of the passenger door. There was one cop, Pfeiffer. Pfeiffer's first, okay? Hodges is behind, a block behind Pfeiffer. And if you look at Pfeiffer's grand jury, he sees, and the car crashes, frontal collision, and does a 180, right? And if you look at the pictures, the car does a 180 and it's a boxy car. 2 people are dead. It's a high-speed chase, you know, chaotic scene. I know you think cops would never get it wrong, but nonetheless, they do run up and the first cop on the scene sees the driver's side, which is facing him, but he thinks it's the right rear passenger side. That's where appellant gets out. He's the only one that sees appellant get out of that. However, the second guy and he both see Darrell Ingram get out of what they call the driver's side door, which according to the alignment of the car is really the rear passenger door. That's where Darrell Ingram gets out of there. And both those guys say that Darrell Ingram gets out of the
I'm
driver's
sorry,
side
I'm
door.
just looking at the stipulated facts that the government agreed to, and it says officers Pfeiffer and Hodges witnessed a black male subject exit the driver's seat of the suspect vehicle and run into the wooded area.
Exactly. They both saw Darrell Ingram get out of what they said was the driver's seat. So that's 2.
Right. And then you've
one
got
seeing Fultz.
Purnell who stays on the scene with Mr. Fultz, right?
Purnell and Pfeiffer stay on the scene, but Purnell doesn't see anything.
Well, but he sees Mr. Fultz where he falls out of the car.
Yeah.
Right.
Right.
So he knows exactly where he is vis-a-vis the car and which door he's fallen out of.
I mean, I don't know. I mean, what Pfeiffer says is that Fultz gets out of the car and he grabs him and he brings him around to the other side and he sees 2 people getting out of the passenger side, what he calls the driver's side of the car. And then the one that he thinks gets out of the driver's seat, which is Darrell Ingram, runs away, and then Hodges chases after him.
Oh, I mean, I would tend to agree with you more if they had said right and left, because that obviously can get turned around when the car has spun around and you've gotten really confused. But I find it less plausible that police officers confuse driver's side and passenger side.
Right,
But that's-
and just to add on, I mean, we've got another stipulated fact. Officer Pfeiffer stated he grabbed the rear passenger as he exited from the passenger side
That was what Pfeiffer said. Yes,
and dragged him around to the other side. I mean,
that's what I just said.
right.
Exactly.
So hard to, I mean, how do you?
I mean, that's
get
what
that-
makes it.
How do you get that wrong? That seems, that's not even eyewitness. That's beyond, right?
It's good for them. Obviously, it's good for them. This is why when Ferris
Right,
Bond,
and that but
had
it's
the
not
case-
just that it's good for them. My point is, this makes the DNA critical, right? Because the only reason the government switches up its theory of the case is because they can't find any DNA of Darrell on the airbag. And lo and behold, there is DNA on the airbag. And there's a lot of, and I'll just say it, confusing stuff about accident reconstruction, about how DNA can move around in a moving, in which direction the car might be rotating and, but we know that there's two people's DNA on the airbag.
Right, so you have four different buckets of evidence on the IPA, right? We have the police officer evidence, we've just discussed that. You have the DNA evidence, where you have a large amount of DNA and only Faltz's DNA in the middle of the bag. And then you have some touch DNA on the edge of the bag, and we don't know, and it's either Ingram and Faltz.
You're calling
or
it
just-
touch DNA. How do we know it's touch DNA?
Well, we know it's a small amount consistent with touch DNA.
Okay,
That's what-
so that touch is a term of art. It doesn't actually mean like he touched it.
Counsel,
government-
if I could just jump in about the buckets of the evidence here on the IPA claim. I guess where I struggle, because I agree with the questions, legitimate factual questions about what's in the stipulation by the government, and where I began with appellant's counsel was I'm still confused why they led in the briefing with the legal argument. And I'm not so sure that this evidence that might equal preponderance of the evidence to support a IPA claim was briefed to us as support for the IPA claim. And you started out by saying something about that. Can we reach in our decision making a discussion of this if we disagree with the legal argument that trial counsel focused wrongly on appellant's claims of innocence? I mean, claims of innocence yet pleas of guilty.
I mean, I think at this point, it would be waiver or plain error. I mean, I only see a briefing of the legal error claim here. And those were questions. You can't always tell what a judge thinks from their questions, as I've learned many times in this court. So the underlying claim isn't before you. Could you notice that claim or say, you know, that it's plain?
What do you mean it's not before us? I mean, why on earth would they raise these arguments about, hey, the trial court improperly considered the guilt? I mean, they obviously did that because they thought that, you know, barring improper consideration of the guilty plea, there was evidence by preponderance that their client was actually innocent. I mean, maybe the government's argument is, look, you have to remand on this too, because the court, I mean, where does the court actually grapple with Mr. Faltz's reasons for pleading guilty? I don't see it in the court's order.
Your Honor, I addressed the question. That's the way I read the brief. And I think it was a serious enough issue that Judge Blackburn-Rigsby asked me the question. So I assume that she thinks that the way appellant briefed the case is the way that she should maybe consider it.
Well,
So
here's where I'm struggling, so you don't have to speak for me, but we've got layers of claims here.
yes.
What if we feel that the evidence about the government's theory of the reenactment shouldn't have been admitted? That goes to downplay or mitigate the arguments in support of the Innocence Protection Act claim. Do we have to remand to decide that in order to have sufficient preponderance of the evidence to support the Innocence Protection Act claim? Do we need to look back, roll it back a little further and analyze these ineffective assistance of counsel claims? I'd like to start with the Innocence Protection Act claim here. I'm struggling with whether or not it's been sufficiently briefed and whether there are other issues that support that Innocence Protection Act claim that haven't accurately been, we don't have a sufficient record for in the briefing below, in the judge's decisions below. For example, the admission of the reenactment by the government.
I understand. I think if you start with the expert testimony, and if you were to find an abuse of discretion, then you'd be asking the trial judge to do two things. One, judge which of these opinions, and maybe he's going to take testimony on this, relied on the unreliable forensic mapping done 4 years later, and which did not. and which do you consider? And once you've done that, Judge, if you want to, I want you to revisit the IPA issue and give us a more fulsome response because we're concerned about that. You could do that. But again, we don't think the IPA issue is briefed that way, but if you wanted to, you could do that. I wanted to make a point about the expert, Your Honor. The ruling from Judge Christian appears on the November 15th, 2022 at pages 13 to 16. And the bulk of the argument in front of the court was the government's experts say it was reliable method, reliably applied to collect data on the scene, the trails, the gouges, the photographs, the field sketch, and then to do the little computer mapping 4 years later, even though it had been repaved. And yes, the speeds are not as precise, but it's still a reliable method, reliably applied. And although we did argue, we did think that DIAS was the right standard, there were repeated references. The court didn't expressly say, oh, I'm applying Daubert, but they kept calling it a Daubert issue. Take that for what it is. The court said, well, look, if this goes to weight, not admissibility. And I just want to point out to the court that in Motorola, this court said, citing the commentary to Rule 702, the trial court's role as gatekeeper is not intended to serve as a replacement for the adversary system. Vigorous cross-examination, presentation of contrary evidence, and careful instruction on the burden of proof are the traditional or appropriate means of attacking shaky but admissible evidence.
So counsel, you would disagree with appellant's counsel's assessment that the trial court discredited their expert for relying on Officer Miller's notes. Rather, I hear you saying he discredited because he credited the government's theory of how the crash took place.
Well, it's
And gave that more weight.
I'm sorry.
Good.
It's two-step process,
Mhm.
okay? At the very beginning, before the hearing, they moved to exclude the government crash experts, and the court said, you say, your guy says it's not reliable, they say it's reliable, goes to weight, not admissibility. I'm going to hear it all, and then I'm going to sort it out. That's the expert challenge. And then the government also says there's a second basis for that. The government doesn't misrepresent anything. I just invite you to look at the record to see what the government said. Once they testify, however, it's a 3-day hearing. All 3 experts testify. Russell, their guy, says, well, their methods are unreliable. You shouldn't have relied on the forensic mapping. Goes back and forth, lots of testimony. And the court says at the end of that, I credit the government experts about the driver couldn't have missed the airbag. And I understand it to be, look, you showed me a bunch of side impact examples. That doesn't persuade me that he could have missed the airbag, that the driver's head went into this 3-inch space.
So is that reenactment testimony key to support the government's theory of what you call the touch DNA? In other words, without that, could the trial court have given more credence, or could more weight have been given to the appellant's theory of where their client's DNA was or wasn't? Because don't you need this side impact theory or impact theory to be able to show that the minimal amount of DNA of the appellant?
Well, it's a frontal collision, 60 miles an hour, 3 people in the car, everything's going everywhere. And what the gravamen of what their experts said was the DNA on the middle of the airbag doesn't tell you anything about who was behind the wheel. And then he came up with this theory, which was all speculation about a way in which the passenger falls as the passenger could have left the DNA.
Well, it wasn't
So,
total
and the court
speculation.
said,
I mean,
the court said, I'm
some,
not convinced.
there were some mathematical, right, calculations about angles and force. And I mean, I skimmed it enough to see that it's not like they just say, we think, this happened. He backed it up with some analysis. And I guess my problem with the government's assertion that the court did a Daubert-like analysis is that if you look at the transcript, the court's ruling is a paragraph long. There's nothing in the written order about this. And the court just says, I'm going to deny that one request to exclude their testimony. Referring to the reconstruction, to the government's witnesses. That goes more to weight versus the admissibility of these witnesses. If Detective Miller, there's testimony that he was on the scene and he's able to provide that testimonial evidence. And if the defense expert is relying on the reports of other experts, including Miller and Chase, then I don't see why they should be excluded, period. And that's it. And there's no sort of assessment of what you would do under a true Daubert analysis. It really does seem to be like an assertion of, well, they conceded this issue reliability because they relied on it too, which is not accurate because they don't rely on the reconstruction. They do rely on the initial data. And so it sort of misses the question of whether the government's reconstruction report is reliable under Daubert entirely. I mean, it's just not, it's not in there.
The prosecutor says 15 to 16, they rely on all of Miller's data, including his field sketch. That's what the government says, and that is accurate.
That's all well and good. I just don't see a
this is the
Daubert
second reason.
analysis of the reconstruction report.
I understand what the court's saying, but remember, there were pleadings on both sides. The court wasn't under some obligation to spend pages discussing its Daubert analysis. The court ruled weight versus admissibility.
But it has to make one, right? I mean, I just don't see where it even says as a conclusory matter, this passes the test under Daubert and Motorola.
I don't think the court is obliged to make any particular findings here in the absence of a request. For
Don't you
specific
think the
findings.
court has to make a ruling? I mean, if there's a request to exclude this under Daubert or Dias,
And the court denied it, saying it goes to weight versus admissibility. The point, this is what Judge Christian did. Judge Christian had a hearing in 2011, experts. Faults testified, Bond testified, and then he had a 3-day hearing in 2022. All the experts came in. The expert who said, this is how you need to try a case. The expert who said, this is the 3 crash reconstruction experts, 2 DNA experts. Faults testified twice. The court let it all in. The court evaluated it. He did exactly what you want him to do.
See, that
He just
actually
didn't
gives
say
me
it in the
more
wholesome
heartburn.
detail you would like.
Well, it's not a question of fulsome detail. It's just a question of actually seeing what the court's analysis was. And we just, the fact that they put on robust evidence and then this is all you get, it just doesn't inspire confidence. And it's not clear that the court actually did the work that we said in Motorola you have to do.
Well, I would also point out, going back to the substance of the IPA analysis, again, there were 4 buckets of evidence. We have the police testimony, we have the DNA, we have the accident reconstruction, and then we also have the findings about Faults himself. Let's not forget, Judge Christian took the plea in 2006. He was at the sentencing in 2008. He heard the statement, the letter where he viewed it as a finding of, he viewed it as an admission of guilt by Faults. And he also heard testimony from Ferris Bond that his client had told him repeatedly that he was the driver, which he credited.
Mr. Sabo, can I ask one question? When you talk about the 4 buckets of evidence, the DNA, the accident, the police, and credibility findings about Mr. Faults, how much does the weight given to the DNA evidence depend on the weight given to one or the other accident reconstruction? In other words, does there have to be a nexus? It seems to me there's a close nexus between whether the trial court credited one accident reconstruction scenario over another in order to determine what weight to give the varying amounts of DNA evidence that were found.
the court, it was their burden to show it was more likely than not that he was actually innocent. It's very hard to do that when your client is not credited by the trial court after testifying each of 3 times. When your client is saying, oh, I pled guilty because I thought I was the passenger, but when the trial judge finds, I can cite you chapter and verse, you knew you were the driver. You told your lawyer you were the driver. You knew you were charged as the driver. The trial judge
But
didn't
part of-
believe any of the
part
reasons.
those credibility findings seem to be based on kind of a misremembering of the evidence, right? Like so, I mean, back up and you have,
Well, that's their
Mr.
argument. But
you have Mr. Faltz telling the PSR writer in 2006, so before he pleads guilty, he says, I'm not the driver. I wasn't the driver and I'm just pleading guilty because I don't think my lawyer has a winnable case, or he told me that he doesn't have a winnable case. So that predates the guilty plea.
Well,
It's
can I
not
address that?
something that, well, I just want to go through the sequence. Then you have the guilty plea where the government says that the police officers testify from their point of view that he gets out of the back of the car. But that there's DNA on the airbag, and the government doesn't actually say when it's giving its rendition of the facts that Mr. Faltz is the driver at the guilty plea. I don't believe that the government says that. The government says that at sentencing. And that's when Mr. Bond comes back and tries to correct what his client says about not being the driver, and says, well, he just said he wasn't driving the whole time. But he actually doesn't say, I believe at sentencing, that his client was the driver. So, the court's assessment of, well, I heard him admit 3 different occasions, it's not quite accurate.
I just very much disagree with what you're saying, Your Honor. I mean, if you were the trial judge, maybe you could make those findings. Judge Christian made different findings, and this is the narrative that happened. And if you go back and look at the earlier order, and if you look at Ferris Bond's testimony in the 2011 briefing, which is actually still before you, that's the 14 case. I hope you have that briefing. But what happened, what Ferris Bond said is, look, in March of 2006, the government offered to break down the 2 murder 2 charges to voluntary manslaughter. So you're looking at up to 40 years per murder, going down to, and he was maximum criminal history category, so 7 years, 7 years and up, prison mandatory. So he was looking, and the government was agreeing to allocate at the bottom of the guideline range. So you're looking at up to 80 years going down to potentially 14 or 15. That's what they were hoping for. And so he writes a letter to his client. This is in March, the plea's in September. He says, the government is charging you as the driver. You're the driver. And they have this conversation, and Faltz tells him, yes, I was the driver. That's March. Okay.
This is what Mr. Bond is testifying in 2011.
Yes, and the court credited that. And you can think what you want about Ferris Bond. Maybe he should have been more exuberant in 2006, but the man is a Marine Corps former lawyer. He is not a liar. The judge credited him. Faltz told him repeatedly, I was the driver. So what happens is they go to the plea, and the government does this plea offer, which prosecutors sometimes do. They wanted to get the plea. The DNA was in the middle, but they didn't say expressly in the allocution that he was the driver. But then they get to sentencing, and Faltz writes a letter. And well, no, before they get to sentencing, he makes a statement to the PSR writer. Well, and it sounds like he's saying, I wasn't the driver. And, I didn't have the dislocated hip. It was somebody else. And Ferris Bond testifies. I said to him, if you say you're not the driver, you can't be, you can't plead guilty if you're not the driver. Were you the driver? Oh, he says, I said I was not the driver earlier in the day, but I was the driver at the time of the crash. The start of the sentencing hearing, he goes in and says, he makes those 2 corrections. And then Faltz reads a letter when he says, I have countless sleepless nights since that time, because I have been the cause of someone losing their lives to young minds and emotions. And Judge Christian takes that as an admission that he understands that he was the driver, and he understood he was charged as the driver. And then, then we get to testimony in 2011. Faltz testifies, he's discredited. So that's why when you get to 2022, Faltz testifies twice. At the end of this 3-day hearing, Judge Christian is like, why should I believe this guy pled guilty when he said over and over again to me that he was the driver? I know he was the driver. Why should I believe that in the circumstances of this case? And that's why those questions from the court were an earned level of skepticism from Anthony Faltz.
I guess, I mean, I hear you that, you know, what the court was doing was crediting Mr. Bond's testimony in 2011, which is 5 years after the plea. But what the court says is, I'm looking back to what Mr. Faltz said in 2006. And I can tell from that he knew that he was pleading. And that I think is problematic because there's a mismatch. I think what Mr. Faltz said in 2006 doesn't clearly show that he was pleading guilty because he was guilty.
Well, it was one data point, Your Honor, but if you look at what the court said on page 4 of the order, part 2 of the IPA analysis, it discusses all of the Faltz bucket information.
Right.
And, you know, I unpacked it a little bit here, but the court is doing it in a fairly cursory fashion, I grant you, but again, not obligated to do it in a more fulsome way. And this is the credibility determination about Faltz. And this judge knew Faltz. That credibility determination goes a long way to making it very tough for them, not only to show the ineffectiveness claim, which, you know, but
let me-
also the
let me just
IPA
jump
claim.
in there, though, as the chief has already said, this is also intertwined and overlapping. And so the idea that you would credit Mr. Bond in 2011 is not unrelated to the ineffective assistance of counsel claims that are being brought against Mr. Bond and are being brought against Mr. Harn for not effectively attacking the ineffective assistance of Mr. Bond in
We're just-
2006.
We're just talking about prejudice, Your Honor. There's no prejudice. There can be no prejudice in this case when the court finds you told your lawyer you were the driver, and you pled guilty because you were looking at 14 to 15 years versus 80. And that's why you pled guilty. And the plea offer had been explained to you. And by the way, all the stuff that you said, I don't believe any of it.
Could there be any argument that there was prejudice for both Mr. Bond and Mr. Harn's failure to investigate for the DNA at the time of the original trial and then at the first ineffective assistance of counsel claim?
No, and thank you for asking me, Your Honor, because look, so first of all, they should have consulted a DNA expert. I'm not going to talk about deficiency. It's early days of DNA, but it's always good. If a court will pay for an expert, why not get the expert? Because you don't have to turn over what they say anyway. But they didn't do that. And what we know now, after a very fulsome hearing, is all they could have said was, well, based on chain of custody, maybe there was some transfer DNA. But the government expert said that would not have explained a large amount of DNA in the middle of the bag. So that would not have moved the needle. A DNA expert in 2006 would not have moved the needle. Crash reconstruction, I assume that we're going to have the same level of experts then that we had now. The court found that would not move the needle.
What about the question of, and if I'm understanding the record correctly, at the time of trial, when the plea was offered, there's testimony that Mr. Bond was told that appellant's DNA was all over the bag and there was no mention of any other DNA, but there was a written report at that time.
And he reviewed it.
That
He said, I
had
reviewed the
some
DNA
ex-
report. He didn't get the file. He didn't have an expert review the file, but he reviewed the report. And again, I think this is a prejudice case if you're looking at it, but I do want to make a point about deficiency with Ferris Bond, which is this. He made the decision that I'm going to make this case about the police testimony, right? He's going to go in there and say, ladies and gentlemen, the government's own witnesses told you somebody else got out of the driver's seat.
Right, but
Yeah, there's DNA in there's DNA in there,
but
but
there's
we've always said,
DNA. I mean,
That's
you
the
know,
case.
and but I know, but you know, you can say he made a strategic decision, but if he makes a strategic decision without getting all the files and reviewing them and considering whether to call expert testimony based on the files that he didn't get and didn't review, that's not a great strategic decision, right? And at the end of the day, I mean, early days of DNA in 2006, I don't know how early days it was. I think everybody thought DNA was kind of a silver bullet. So saying that 5 witnesses, you know, over DNA is going to, I mean, I just,
Your Honor, I've tried a lot of cases in DC Superior Court. They don't want this case to be boring, schnorring testimony from a DNA expert about possible DNA transfer that doesn't actually explain the large amount of DNA in the middle of the bag. Make the case about the cops, the guy who was in the car. That's the way he was going to try it. The fact of the matter is, whatever you think about deficiency, this case is about prejudice. There is no prejudice because what we know is the Innocence Project and a big law firm, they spent 3 days, all the experts were hired, and at the end of the day, they still had no preponderance of actual innocence. And even back then, most of the DNA evidence that they brought forward later, everybody agrees was not available in 2006.
What was the finding, or was there a specific finding by the trial judge that there was no preponderance of actual innocence? And was that, yeah, let me, remind me, we had findings at all these different hearings, but I don't remember what the meat of any finding was at the IPA, or at the Innocence Protection Act hearing.
Well, I mean, if you look at pages 3 and 4, those are the court's findings on the IPA. And the court says it is unconvinced by the defense proffer. And again, it's their burden. He says they haven't met their burden. That's what the court, those are the ultimate findings of the court.
All right, any further questions? No, we've gone way over your time. It's simple.
Thank you.
Thank you. Counsel, I know you reserved some time for rebuttal.
Thank you, Your Honor. I want to start with Daubert very briefly. The government.
Before you get to Daubert, can I ask you to address the prejudice question about Mr. Bond and Mr. Harn's failure to call an expert at the time of trial and at the post-conviction hearing on DNA?
Certainly. Both the court and the government here are relying on the fact that Anthony pled guilty to show that there is no prejudice, because if he pled guilty,
Well,
he
no,
must therefore be
well, with
guilty.
respect to the DNA, though, what was ultimately shown or not shown, known or not known, that would result in prejudice with respect to failing to do more with the DNA evidence?
So as I mentioned earlier, the DNA evidence was the critical evidence in the court's case. So any avenues of attack, including the fact that there was a mixture which was known, had that been explored, there would have been a reasonable defense. And it's important to think about the legal standard here. In Lee, the court said that we look to whether there is a reasonable probability that but for counsel's errors, would the defendant have made a different choice? Would he have not?
I think we're
pled
asking
guilty?
something, I mean, I don't want to speak for the chief judge, but I think we're asking something a little more specific than that, which is, let me ask you directly, at the end of the day, on both the IPA and the IAC prejudice prong, am I right that what you have is the trace amount of DNA on the right side of the airbag? And that's it?
I don't believe that's it. But I'm not sure that I'm following your question as to the prejudice.
If Mr. Bond had engaged in the inquiry that you say he should have engaged in, and I'm also assuming that the DNA testing that is available now would have been available then, which is not the case, but let's just assume that I mean, all you have now is the trace amount of DNA on the right side of the airbag, right? So what more would you have had then if Mr. Bond had engaged in the inquiry that you say he should have engaged in?
Mr. Bond should have engaged in both a DNA inquiry, in an accident reconstruction inquiry, in a medical injury inquiry, all of that
But
evidence.
I'm not
would
asking
have
what
been
he should
presented.
have done. I'm asking what you think would have been the outcome of that.
I think the outcome, had he done that investigation, the outcome would have been that Anthony would have gone to trial as he walked
But
in.
based on what? Based on what? Is
Based
it
on,
just is it the DNA evidence on the side of the airbag?
based on the fact that there was a mixture of DNA on the airbag, that there was an accident reconstructionist who could explain why his DNA was on the airbag, and the testimony of the officers. That would have been enough for him to have chosen to go to trial. And under Lee, that choice, even if it's highly improbable that a defendant could have won, if that choice had been different, there's prejudice.
Okay, but you would agree that my assumption that the DNA on the side of the airbag evidence would have been produced, or would have been obtained back in 06 was, I mean, that's a false assumption, right? Because that testing wasn't available.
That particular testing was not available. So
So,
you would look to the fact that there was a mixture which was inconsistent with the government's theory that all the passengers had to move straight forward.
but I don't think it was, because the theory was that the vast amount of DNA that would have been attributable to the driver was in the center of the airbag, and that was all Mr. Fultz's DNA. And I think that theory has remained the same from back then to now.
The theory remains the same, but there are problems with that theory. For example, and this was raised at the evidentiary hearing and could have been raised back in 2006. Chase says everyone moves directly forward such that the driver must contact the center of the airbag and is the only one who can contact.
So the trial
center.
judge did not credit that testimony.
The
Correct?
judge does credit Chase,
He
who's the
does
government's
credit, the
expert.
government's, I'm sorry.
There's a huge flaw between the evidence and Chase's theory, and that is this. There's no dispute that someone was sitting in the front passenger seat of the vehicle. Chase explained that, like the driver, the front passenger would have gone straight forward into the airbag and would have been more likely to hit the airbag because a passenger airbag is larger. There was no DNA found on the passenger airbag, and Chase could not explain that and could not reconcile that with his theory. That too could have been presented in 2006. If I may now move back to the Daubert issue very briefly. The government has based its argument on the fact that we defer to the trial court's decision and the trial court defers to an expert. But the case law is very clear that the court cannot abdicate its responsibility.
And you say
as a
defers
gatekeeper.
to an expert. The trial judge, I didn't read the information in the record as him deferring to the expert. I read it as him hearing the testimony from both experts and crediting one and not crediting the other.
I mean, in the initial gatekeeping decision, it deferred to the expert in the
By
sense
allowing it in.
that it allowed it in and said it was a weight issue.
Was there a challenge, when, I assume there was a challenge at trial, at the time of the hearing to admission of the evidence?
Yes.
What specifically was said in the challenge?
So before the evidentiary hearing, we argued that the Miller report and the Chase report should be excluded as unreliable and speculative. The Miller report, and this is important because Miller did two things in this case. He was a detective who responded on the night of the collision, took photographs of the scene, took measurements on the night of the collision. That is not part of his expert report. That is separate. His expert report is solely a document that he put together 4 years after the collision. He returned to the scene to put it together, though he conceded that no scene evidence remained at the time that he went back. No skid marks, no gouge marks, no debris in the road from the accident. In fact, the road had been repaved at that point.
But are you faulting the absence of his initial night of accident?
No, that is not part of his expert report.
Right, but are you saying that that's a problem?
It is not a problem.
Because that strikes me as being the right way to do it, but we don't want to mix fact witnesses and expert witnesses.
Correct. And that's what both the court and the government have done. In arguing that the defense expert relied on Miller's report, the government's not talking about Miller's report at all. Defense expert did not rely on Miller's report. Did he look at the scene photographs? Of course, he needed to for his reconstruction. The government did not, the court did not carefully parse through this. It did not look at the reliability of that report and that report alone. And Miller himself on the stand, unprompted, stopped me during questioning and said, "You can't call my report a reconstruction. It is not a reconstruction. It is estimates." That evidence was speculative and unreliable. It should have been excluded. Chase adopted Miller's report as part of his own and relied on it under the misapprehension that that report was conducted immediately after the collision while scene evidence remained through forensic mapping. So Chase did not even have the wherewithal to understand Miller's report. He relied on it blindly to come to his conclusions. By not looking at this carefully before the hearing, by not fulfilling its gatekeeping role, the trial court abused its discretion. I also want to go back briefly to the discussion of the IPA. If a court refuses to apply statutory framework, then its decision is wrong. And on the merits, it is impossible to know what a correct analysis by that court would find. So I would submit that we have properly briefed this and that the IPA and actual innocence claim is before this court. Thank you.
Thank you. We'd like to thank both parties and counsel as well as the Innocence Protection Project. I see some of your counsel in the courtroom for the briefing and arguments on both sides of this case today. Thank you. All right, our second case is in re Michael Alexel. All right, thank you. I know counsel is appearing remotely, so as soon as that connection is set up, we'll begin.
Good morning. I believe I'm all set. Thank you.
All right. Well, counsel, ready to proceed? Can you just state your name for the record, please?
Sure. May it please the court, Jack Metzler for the Office of Disciplinary Counsel. I'd like to reserve 2 minutes of my time for rebuttal.
All right, and I apologize, counsel. I can't, is it Miss Paulding? I can't read your name on the.
Yes, ma'am.
Okay, good. Thank you. All right, counsel, you can begin.
Thank you. The facts of this case are undisputed and the issue is straightforward. May an attorney pay himself for part of a flat fee representation without the client's agreement? Under the court's decision in Mance, the answer is no. A flat fee encompasses all of the work to be performed in the course of an engagement, and the fee agreement controls how that fee is earned. If the fee agreement is silent, then the flat fee is not earned until all of the services.
Counsel,
are performed.
sorry to cut you off so early, but I'm not sure Mance answers this question one or the other. It seems to say, I agree with you that it says a flat fee is not earned the moment it's paid into the paid to the attorney and deposited in the client trust account. and therefore can't be moved immediately into the operating account. I'm not sure it says anything about what happens after that with respect to when the the attorney starts earning the fees. So it seems to me, I know you've pointed in your brief to some spots in Mance that might touch on this issue, but I don't want to speak for all of us, but I would prefer to hear why you think what you think the right rule is aside from Mance. Although I'm not trying to tell you how to make your argument, but
Sure. Well, so
I would
go
just
back-
echo that. I'm not sure Mansa resolves this question of law.
So I think the answers are all, I would rely on the same reasoning that the court used in Mance. A flat fee is, it's like when you order an Uber, you get one price for the whole trip. The driver doesn't earn part of the money by getting you halfway there or part of the way there. He has to take you all the way there. Now, there's another option that's available. You could hire a cab, and when you hire a cab, you pay by the distance or you pay by the time that the cab is working. And if you is
The
driving,
analogy, that's not, sorry to quibble with your analogy. I mean, you can have a lawyer and hire them to handle the whole case. And they can do some discrete tasks that are beneficial to you. And then, for whatever reason, you all decide to part ways. And it seems to me that, it would be perfectly acceptable, arguably, to say, well, the lawyer gets to draw on the flat fee when they've done the work. And I actually thought your argument was a little bit different. I thought you weren't saying that it's not okay to draw on the flat fee as you do the work. It's just that there has to be an express agreement to do that.
that is the argument, yes.
Okay,
So, but
right. So it's okay to say, as I do the work, if I have an agreement with my lawyer that, I'm gonna pay them $10,000 to do whatever job. And as they do the work, they can draw on that $10,000. That would be okay.
Sure, and
Does it have to be more express than that?
well, this is discussed in Mance, and the court, explained that when you you could agree to milestones, you could agree to some other any reasonable arrangements, as long as it's not.
I mean, getting more granular than that sort of undermines the whole point of having a flat fee, right? Because then you might as well just get the billables and review the bills each time. But the whole point of having the flat fee is to say, we're going to make this easy. Generally it my time doing this work. Now I've flipped roles. Now I'm the lawyer, you're the client. It takes me, about so many hours, and I have to do so much work and have this much, support staff time. So it's about $10,000 to do this work. And you say, okay, instead of me sending you bills and trying to get you to pay me. And that's a lot of work and actually increases the cost of the job, right?
Yes, Your Honor, that's exactly right. That's the advantage of a flat fee agreement. But there's something that comes along with it, which is that they are paying you, the client is paying you for the whole job. They haven't chosen the cab option, they've chosen the Uber option. And so
But wait, now I feel like you're going back and saying this isn't about whether or not you can draw it down. You can't draw it down, period, until the job is.
Well,
I mean,
both cases,
in
Your
that
if I-
world, like you give me the $10,000, but I just hold it in escrow until the bitter end, and I don't get to draw down on any of it.
Well, you as the attorney get to control this. You do get to control it because you write the fee agreement. So you can choose, if you like, to come up with an arrangement so that the client
Can I just-
authorizes you to
Counsel,
draw
can I
down the
just
money.
jump in for a second? Because I feel like your interpretations runs counter to some of the actual language in Mance. I think even though Mance didn't clearly hold that you can draw down in installments or words to that effect, it does say that only to the degree that the attorney actually performs the agreed upon services, the fee must be held as client funds in a client trust or escrow until they are earned by the lawyer's performance of legal services. It doesn't say until every single thing that's set forth. And here, I guess under the facts of this case, it's hard for me to see where counsel ran afoul. They had an agreement, money was deposited. He did portion of the work, drew down a portion of the fees. He's able to explain in the hearing committee report what work he did. There were various addendums. There's no objection, at least with respect to the first drawdown. I guess I don't, I mean, suppose it took 5 years is counsel supposed to work for 5 years while the fee sits there and get paid for nothing while accumulating certain expenses and costs?
Sure. Okay. So there's a lot in that question.
I know, and I'll add
try
one
to-
more.
I'll try to get
Your
to,
quantum root analogy doesn't help me here. Like if they terminate after he's done half the job, but not all the job, he has to refund all the money and then sue to get, I guess, I'm quibbling with what you say the rule should be to
Okay.
some extent.
So to start with, I think the first part.
Sorry about that.
Of your question. So in two places, the court in Mance explains what and I agree with you. It doesn't say, when we say until earned, we mean until the end. It does that by saying a flat fee encompasses the entire engagement and, number one, and number two, you can only earn the flat fee by actually performing the services. Okay, so put those together, 2 and 2 means you can only earn the entire fee by performing the entire services.
I agree with that.
Okay,
You can only earn the entire fee by performing all the services.
right. So then the question is,
I don't
can you
think the
pay for part
inverse-
of it?
Yes.
Can you pay yourself as the attorney for part of
No,
it?
no, can you earn part of it and then
Okay,
recoup
so
that?
so the question then is, what does the court mean when it says earn the fee? And I think the only way to understand that is you earn the fee when you're entitled to pay yourself from the money, right? So if the agreement says at milestone 1, you get half the fee. You can
I'm
pay
sorry to
yourself
keep
then.
interjecting, counsel, when you're trying to answer my 5 questions already, but shouldn't it be, if the language I just read in Mance is true, that you earn the fee when you perform the services?
So no is the answer, at least according to Mance. And I'll tell, and the opinion does this in 2 places. It says on page 1204, it says the default, well, 1206, it says the default rule, but it says on page 1204, you need to keep the money in escrow until earned, and hold that. And the alternative is to agree with the client as to when the fee will be deemed earned according to the agreement, according to milestones or whatever. So until earned is a point in time, right? And now I agree with you. One way to look at that is to say until earned means, well, if you work an hour on it, you've earned a little bit. If you work a second hour, you've earned a little bit. That's sort of the platonic sense of earning. But that's not what Mance says, because if you take that rule,
Mance just doesn't answer this question, right? Mance was, as Judge Schenker said at the very beginning, who does the money belong to as soon as you hand it over? Right?
Right.
That's the only question Mance answered. So we're trying to figure out what the rule should be. And so telling us this is what Mance said or didn't say isn't helpful to us in figuring out what the rule should be, right? So
okay,
we're trying to figure out if you hand over a flat fee and the lawyer does some of the work, can they get some of the money out of escrow that has been paid to them already?
they absolutely can if they set that up in the agreement.
And you
And-
think that it has to be in the agreement? And my question is, how express does it have to be? Can it just be, I agree to do this work for you in return for a flat fee that I can draw upon as I do the work?
Well, I think that it would have to be reasonable is.
Well,
it would have to be a reasonable
I'm
fee.
telling the client, I'm gonna do the work. And as I do the work, I'm gonna draw upon the flat fee that you have given me. I'm being clear, express, I'm making the call about when I do the work.
So I think, don't hold me to this in a future case, but I think the answer is that wouldn't really be reasonable. And the way that I think to look at it would be to explore the edges of what an attorney is allowed to do. And the misappropriation question is whether there is an authorized use. In your hypothetical, the attorney could say, well, in my mind, I'm not going to tell this to the client, but the consultation is really worth a lot of money in my mind. I charge $10,000 an hour for a consultation. The rest of the work I think is, more mundane, but I really do a lot of work in that case. So when you give me the upfront fee, and at the end of our hour, and I'm not going to tell you this, but I've earned the entire thing right then. And that's exactly what
And the
Nance says
rest
you're
of the
not allowed to
services
do.
are zero.
Well, that's worth things too, but I'm going to do that as well.
But we're talking about a flat fee of $10,000.
Well, exactly, for the reason that we've discussed. It's just easier for me to do it this way. I would
That
rather,
just seems like an end run again around Nance.
well, and
But
like I say, I'm
But in
exploring.
my
Yes.
hypothetical, I actually do, it's not just the consultation. I actually file some motions, make some court appearances, but I do not finish the job.
Sure.
But I draw on the $10,000 payment that you gave me. Is it reasonable if I have an agreement with you that says I am going to pay myself as I do the work?
I mean, I think you would have to have a reasonable basis because otherwise it would
I
be.
have a reasonable basis. I
Well, there would have to
actually
be a
did the
reasonable
work. I
basis.
actually filed the motions and, right, in my hypothetical, I actually did the work. I mean, I see your point that, there could be some nefarious lawyers who don't do the work, and that's a problem. And I think that they could either file a complaint with Bar Counsel or, seek recompense in other ways, right? But in my hypothetical, I do the work, and we're talking about what the arrangement has to be for the fee for the lawyer to draw upon the funds that he or she has already been paid.
Sure. Well, I mean, I think we can disagree about what might be a reasonable basis in a fee agreement to draw down in the circumstances that you
Because my
suggest.
point is, again, I mean, I'll just get back to it. I'm trying to figure out what the point is of having a flat fee to begin with. If you start requiring lawyers to actually sort of bill for a particular time, then they might as well just bill for a particular time.
Well, it doesn't require them to bill for time. This is in the lawyer's control, right? They write the agreement. They could say, for example, Alexi could have said, he split it up already into $2,500 at the outset, $2,500 at the end. He could have said the first $2,500 is basically earned hourly, and then and the last $2,500 is earned and due when I'm about to file. That's essentially what happened here. But he didn't do that, and that denied his. He said $5,000 total for the entire course of the representation, and that denied
That
his
just seems to
client.
be breaking up the flat fee into chunks.
But
Well,
counsel, I mean, isn't
that's
that
exactly
your,
the milestones, right?
right, isn't that your, I mean, shouldn't you, I'm not, don't take this the wrong way for either of you, but shouldn't you respond to Judge Easterly's question by saying that's exactly my point? Because that's when an attorney chooses to charge a flat fee versus an hourly fee. So if they've chosen to charge a flat fee, then they're on the flat fee path. And to now say, I'm also going to charge you hourly, essentially, by being able to draw down the flat fee on my hourly basis, then you might as well have just charged an hourly rate, which is what Judge Easterly said. But you didn't do that. You charged a
Sure. Well,
flat fee. So
I mean,
at that point, you should, shouldn't your answer be that you have to break it down by discrete legal services or milestones?
well,
Or-
I mean, what the Mance decision says is, yes, you have to break it down by
Well, just to-
on any reasonable
To
basis.
piggyback off of Judge Schenker, though, is if you break it down into what you're calling milestones, why isn't that essentially you're just charging incremental flat fees, right? I
Well,
mean, and
you
now
certainly
you're
could
just
do
sort of
that.
saying, well, you can't charge a whole flat fee for the whole job. You have to charge incremental flat fees. And at which point, why not just bill? and-
Well, no, Your Honor, you can absolutely charge a flat fee for the entire job. And
But you
the
can't
point
get,
here.
you can't draw, on your view, unless you tell people your milestones, then you can't draw on that. And so it means that you actually are giving people milestones, which in my view just seems to be you're giving people smaller flat fees
Well,
incrementally.
It could be that the court
And
wants
so
to.
conceptually, I'm not sure how that protects the client more or less. It just means, I guess, that there's less money on the table.
Well, I think the balance that the court struck in Mance.
I mean, I guess the point is, it seems like you're sort of assuming that lawyers are going to be not above board in charging their clients, but isn't the presumption the opposite? I mean, you know, everyone swears an oath and has obligations to their clients and, you know.
So I think the rules set out the conduct that attorneys are supposed to follow, and unfortunately, they don't always follow them. And so we need to set the guidelines so they know that they are going to be within the rules and not without of them. And just stepping back for a moment, we're talking in this case about misappropriation, and there's nothing new to say that misappropriation, this court has said many times since 1980 or something, that misappropriation is the unauthorized use of client funds. And so if the funds, if the use of client funds, paying yourself, has to be authorized, it has to come from somewhere. And even before Mance,
Are there,
attorneys knew
what
that.
about after Mance? I mean, what about, I'm not sure if In re Gray is on all fours here, but in that case, which involved misappropriation of funds from a number of clients, we seem to determine that in some circumstances, it would be improper to leave earned funds in the client accounts. And so if some work is done and funds are earned and those aren't moved out, as counsel did here, Mr. Alexi did here, doesn't that create another potential issue? I guess,
So
what
I
other
think the answer
cases
is-
other than Mance would you use in support of this question here that we don't feel Mance squarely answers?
So you could look to, for example, we cited several cases from other jurisdictions that impose exactly the rule that we think Mance laid down, and that the court, if you don't think Mance did it so already, we think you should impose that rule now. And the ABA opinion, which came out last year, it's also cited in our brief, concludes that this is also the correct approach for flat fees. But I'd like to return just for a second to the policy reasons that are described in Mance. Now, it's not.
Does In re Gray have any applicability here?
So I think the best applicability of Gray is is that it says that an attorney who has a mistaken belief about the status of funds, that has to be objectively reasonable in order to make it negligent. But as far as the question of whether funds should be left in the account or whether they need to be taken out of the account, the fee agreement really, which is in the attorney's control, defines whether the use is going to be authorized, whether the funds are then at what point they belong to the attorney rather than the client. And again, this is all within the attorney's control.
I mean, you're saying your answer is Gray doesn't apply or doesn't answer the question because it just begs the question of whether the fees have been earned or not. And your point is that they haven't been earned.
Yes, that's correct.
If the flat fee is to do X, they haven't been earned until X is done.
That's correct.
So Gray
Or-
is the inverse of the situation. But it still rests on whether the fees have been earned yet or not.
Right. So I don't think there's any dispute in Gray that the funds that the money that from multiple clients, he just wasn't paying attention. He didn't know what he had earned, what he hadn't earned. It was he just had lost complete track of what was going on in his over a number of years of what was going on in his trust account. That's quite different from here, where Mr. Alexi knew that the funds were unearned when he put them in there, and what the opinion in Mance says is that the payment was for all of the services, and so it's not like he agreed with the client that they had been earned at some point.
So counsel, going back to what an attorney and a client can agree on, and drawing on Judge Easterly's earlier question, I mean, the rules to me says that the client can give consent to a different arrangement, meaning unearned fees can be treated as property of the attorney if the client agrees with that, which would basically undo Mance by agreement. So as soon as the client pays unearned fees, if they agree with informed consent, the attorney can treat that as property of the attorney and place it into their operating account. The rule does not, to me, on its terms, seem to contemplate an agreement that unearned fees, about when unearned fees can be deemed earned fees. Do you see the distinction I'm trying to draw?
I do. And I agree with you, but I think I think that question is answered in Mance, where it uses the same language, may agree to another arrangement, and it does this twice, contrasting the until earned with as earned according to the agreement. And then the Mance opinion talks about the milestones and how the milestones have to be reasonable. And I agree, those don't appear on the face of the rule, but those are the authoritative interpretation of this court, and therefore they control. But going back just for a second to the policy discussion in Mance, the court weighed the interests. Like, it is inconvenient for a court for an attorney to be without the funds, no doubt. If he wants to wait until if he doesn't agree to anything else, no milestones, no anything, it is inconvenient for him to wait until the end of the representation to get the money. But the court balanced that. It said, sure, we understand, but the balance has to favor the clients, because the client doesn't know what the attorney is doing with their money. And Mr. Alexi's client didn't know what he was doing with the money. He didn't tell her he had taken out almost all of her deposit, within a month, when the forms weren't going to be filed for another 6 or 8 months later. She didn't have the opportunity to challenge that. And I'll note that if she had challenged it, he would have had to keep that money in escrow, right? So the rule that the opposite rule, the rule that the board would have you apply, is that Alexi gets to take the money out when he feels like it's earned, treat it as his own, spend it, whatever. He doesn't have to tell the client. She doesn't have any opportunity to challenge it. And that's just fine. But the court made the opposite. Now you could change your mind. You could decide that the attorney's interests and the convenience, not having to do bills or anything else, that is more important than the client's interest. But that's not the way that the court has done it so far, and that's not how it should do it today. Now, with regard to, I'm going to go to the sanction for a moment. I suspect that
If we think that Mance did not decide this question, because Mance just said, the question that we have before us is who owns the money at the moment that it's transferred from the client to the lawyer, right? Didn't talk about what happens with the earned fees, right? Said that you can make an agreement to have an end run around the rule for unearned fees. If Mance didn't decide this question, shouldn't this case be treated like the respondent in Ray Har, where it just wasn't clear what the rule was vis-a-vis earned fees?
I think if that were your holding, that would be a reasonable way to resolve that he had an incorrect understanding. But if you don't believe that Mance was clear enough, then that would count as.
There was also ethics opinion 355, right? That suggested that Mr. Alexi's reading was right. And I don't know when that was withdrawn or if it was withdrawn. I mean, all I've seen is that it's no longer on the website, but I don't know what that means.
Well, so you could see the ethics committee filed a petition for rehearing in bank in the Pons case. And there it explained, we're very concerned about your opinion in Pons because you have said that informed consent to another arrangement under the Mance decision has to be in writing. And you said, we know you said in writing, but we don't think that's true. You should rehear the case. And the court didn't do that. And in that brief, they say we have taken the unusual step of taking this off of the website. But now, as regard to ethics opinion 355, and I just want to point this out because it's not in our brief. If you go and look at the Pons case and you go look at the board's opinion in that case, the board said what it thought Mance meant. And on page 4 of the board's opinion, it said, after Mance, an attorney who wants to charge a flat fee has four options. And option number one was put the money in escrow and keep it there until the end of the agreement. So that's what the board thought in Mance meant before this case. The other three options, one of them is agreeing to milestones as described in the Mance decision. One is don't even charge the client until the end. And then the last one is what Pons had to do with, which was the agreeing to by informed consent to treat the funds as the attorneys at the outset. So
I guess I'm confused as to why you're telling us what you think the board thought Mance said.
well,
I
I
mean,
think I get a
we would
suggestion
be
that
the best interpreters of what our case law said, right?
I absolutely agree with that. But to the extent that that the ethics opinion is relevant with regard to.
I mean, it
to
seems
this
like
issue.
there's confusion about what Mance said about this issue at best. And so that would
Sure.
um,
Well,
be factored in any sort of sanctions analysis.
and that's appropriate. But just to make one further point as to why this is the correct rule. And I think the way to look at it is again, to look at the contours of the rule that you're imposing. And we expect attorneys to obey the rules and to follow this court's opinion. But they don't always.
I guess I know you're over time, but if you could just articulate for me in one sentence or two what you think the rule is
Sure.
or should be.
Right. So the rule is that that a payment is only authorized and the money is only earned to the extent that the fee agreement sets that out. And so if what Mance says is that the default rule in the absent, if it's silent, you have to complete all of the work to earn all of the fee, but you're free to set reasonable guidelines. And that's the rule. In this case, Mr. Alexi didn't do that. He came up with his own basis that he didn't, an hourly rate he didn't mention, and a amount of hours that he didn't disclose to anybody, and used that his own basis to take.
Is there any argument that he didn't actually do the work or that he billed improperly for the work that he said that he did?
I mean, he didn't do any bills. The hearing committee accepted his testimony that he worked a certain amount.
There's no finding that the amount that he said and he worked and the amount that he deducted from the flat fee was unreasonable, is there?
We did not make that argument.
Okay.
There was on the second withdrawal, the hearing committee believed we had not established the negative, that he hadn't earned it. And I would point that out because that shows the difficulty of this sort of situation when the payment is not defined, right? It'd be very difficult for us to overcome an attorney coming in post hoc, no matter what he did, whether he did anything or whether he did nothing. And he comes in and says, no, I did work that time. I didn't write it down. I didn't tell her what the hourly rate was going to be, but I worked plenty in order to earn what I took. The
Counsel,
attorney could always say that.
did I understand you correctly when you said that just now, the rule in Mance is that in order to earn all of the fee, you have to do all of the work? That's not how you said it. You
I
said
say the default rule
is that,
is that in order to earn the entire fee, you need to do all of the work. Yes.
okay, but that doesn't encompass the rule that in order to earn any of the fee, you must do all of the work.
Right. So, I mean, I suppose the answer is that the fee agreement needs to define the authorization to take the money and treat it as your own, as the attorney's property. And if it doesn't, then that's what I think Mance says, that the default rule is it needs to stay in trust until earned. And the alternative is defining with the client when it is earned, when it is deemed earned or how it is earned per the terms of your agreement. It wouldn't make much sense. I mean, the Mance decision doesn't make much sense if an attorney is free to do what Alexi did here. There's no reason to
So
set that
going all
out.
the way back to the beginning then, and piggybacking on Judge Easterly's question of what you think the rule is. could an attorney say, I mean, I agree with you, or I tend to agree with you, that if the flat fee arrangement is, I have to file X and you pay me $10,000, that the rule could be you don't earn X, and that's all the agreement says, that you don't earn the fee until you file X. Could the agreement say, you're paying me $10,000 to file X? In addition, my hourly rate is $200 an hour. If halfway through this, or if in a year, I have not filed X and you decide to withdraw, to terminate my representation, and I have given you notice of my hourly rate, and I give you a billing statement that says how many hours I worked on this, that I'm entitled to keep that prorated amount, hourly rate. Could an attorney and a client agree to that?
I think at the outset, that's not unreasonable. That wouldn't be a unreasonable fee under Rule 1.5. Now,
That would or would not be?
would not be
Okay.
an unreasonable fee arrangement. In a particular circumstance, it very well might look unreasonable if the attorney has no work product to show and says, nevertheless,
Not
I
a problem with the
100%
agreement.
fee.
That's a problem with the evidence that they put forward, right? I mean, under Judge Schenker's
Yes.
hypothetical, the agreement is, I will give you a billing statement.
At the end. So,
If,
I'm-
if you decide to terminate our services before I have done
Yes.
the ultimate task, I will give you a billing statement showing you the work that I did.
Yes, I don't think
and-
that
and
certainly at
telling
the
you that
outset.
I'm going to draw down on the flat fee from that. I guess my problem with that is I think a lot of lawyers charge flat fees because they don't want to keep track of hours, right? Which is time consuming. And they can just say, I'm going to take, this case and I've seen this case 100 times and it generally, takes me about this amount of time. So I charge X for this.
And I don't disagree at all. That is why the clients, why lawyers use this type of agreement. And I think, if you have, this is why the agreements we have are things, the cases that come over are things like this. It was an immigration form. No doubt Mr. Alexi knew what was involved, and so felt very comfortable about what it should cost to do that. But there is a balance, right? If he thinks it's going to take 8 months and he really is going to need the money before then, he has to balance that against his knowledge versus the chance that it's not going to work out the way he wants, and he gets to control it because he writes the agreement. Now it could be opening the file, just write down a few things, opening the file, doing legal research. I will earn 10%, anything that is reasonable, but he has to tell the client because that's the only way to know that the payment is authorized. And I would like to just make 2 more points. One is to go back to before Mance. Back then, it's no secret that the payment has to be authorized. Back then, the agreements would say it's earned upon receipt. That was the authorization. The attorneys knew they had to have some reason to treat that money that the client was giving them before they did anything as their own. And so they put it in their agreement. They said, this money is earned as soon as we take it. And that was a good justification. In Mance, the court said, you cannot do that anymore. So the question is then, if the agreement says nothing, where does the authorization come from? It doesn't come from the rule. It doesn't come from the Mance decision. What the Mance decision tells you is the opposite. The
man
fee to pay-
says that it's yours when it's earned.
Right, but
And-
where is the
and-
authorization to pay it, or to take the money, right?
Well, Mance just doesn't speak to that, right? And just says,
Well-
you get it as soon as it's earned.
Well,
and
well,
so
I
now-
disagree. So what
Okay.
it says is it contrasts the until earned with the option to set out when it is earned and take it at in the course of the agreement. And it wouldn't make a lot of sense to do that if the attorney could just to do the same thing without coming to any agreement. And I do want to address the quantum Merowith point because
Thank you. That was a question a while ago, but
yeah, well, there are many balls in the air. So quantum Merowith, if you imagine, like, for example, you hire a contractor to replace your roof. and you're going to pay him $10,000 to replace the roof, right? There's two steps. One is taking off the old roof and one is putting on the new roof. In some sense, you could say he's earned half the fee when he takes off the old roof, but that's not what the contract says. The contract says you get $10,000 for the whole job. So if the representation or the relationship ends, he's whatever reason, he doesn't want to finish it. You're left with half the job done. He doesn't get the $10,000, right? Because there is no contract anymore. The contract was for the whole set of services. So Quantum Merowit says, right, we're not going to put him out. This operates when there is no contract. And when there is no contract, he gets the value of what he did. And it may turn out that, that winds up being half of the contract price. So, a flat fee representation is similar. It's what the court said in Mance is it encompasses the whole job. It's taking off the roof and putting it back on. And if you want to say, I'm going to take $5,000 at the first milestone, you just need to establish that with the client. If you don't, then you're operating in the, and the representation ends, then you're operating again without a contract and you get the value of what you, of your work, right? So, but it's not controlled by the fee agreement. That's just sort of an equitable to make up so that you aren't lost in this particular.
But do you literally have to go to court to get it?
I mean, no, you don't. You could agree, if I had this with my, I had my roof redone a little while ago. And if the roofer had taken half of it off and for whatever reason couldn't finish it and I found someone else to finish it for the same amount, I think we would agree that he could have the 5,000 and I'll pay the other 5,000 to the other person. You could also go to the arbitration board. But the point is, if there is a dispute, there are ways to resolve it. There might not be a dispute.
But the difference though is, the roofer only gets the $5,000 in a Quantum Merowit situation if the work that he or she did is then can be applied toward the work, conferred a benefit on the homeowner
Sure.
such that the work can be applied to the next worker. If an attorney, I'm not saying this undermines your position, but I'm mostly doing this because it reminds me of law school. But if the attorney just does legal research and pulls a bunch of cases and thinks about the case, I suppose they could turn over their case file to the next attorney and that might count for Quantum Merowit, but otherwise it doesn't seem like it would, right? So in that situation, the attorney would probably be out the money.
Well,
Right.
they might be. There will be a factual issue as to how much the value that the attorney provided to the.
I mean, what if the
Fine.
attorney does a bunch of research and follows up on a bunch of possible arguments and figures out, these are just not viable? That is work that needed to be done to zealously advocate for their client and they don't get paid for it?
Well,
Because
so
under a
if we're-
Quantum Merowit
if we're in the
situation that
Quantum
didn't
Merowit-
benefit the client? I
Right,
mean,
so-
it did benefit the client in some way, right?
Well, if we're in,
I mean, this is
Quantum-
why I think that lawyers and contractors are not analogous.
well, the question is, what is the best arrangement that's going to protect clients? If you're.
How much of a problem is this?
Oh, it's a very big problem. We have the hard case, for example, especially in matters like criminal cases and in immigration cases. There are attorneys who don't keep any track of anything, and their clients are their
And
clients are
don't do the
uninformed.
and don't do the work.
Oftentimes they don't, or they provide incompetent representation. And like as far as I can't give you a number of complaints that refer specifically to the attorneys taking fees, but when we look.
I mean,
at
it seems like the problem there then is an ethical problem with lawyers not representing their client in a way that's consistent with the ethical rules, but the disciplinary council seems so focused on misappropriation as the sword here, as opposed to following up with all the other rules that require effective representation. Why are we going at this through misappropriation?
Well, we go at it through all of in this case, we brought a range of charges that included incompetent representation.
But you only filed the exceptions, I understood, under 1.15, correct?
That's correct. We were trying to make it easy for the court because, if you agree with us about what Matt said, this is a very easy case. And I think for the reasons articulated in Mance, the rule that we are advocating is the right one, regardless of whether you think it was actually set out in Mance or not.
Counsel, I know we've gone way over with your time and you reserved some time for rebuttal, but let's hear from counsel for board, Ms. Paulding.
Thank you.
Thank you.
If I may inquire, will the timer be set up? Ah, perfect. There we go. May it please the court. My name is Kristen Paulding on behalf of the respondent, Michael Alexei. To start with disciplinary counsel's argument regarding whether or not the contract was insufficient or whether it was ambiguous, I find that interesting because disciplinary counsel did bring 7 different charges against Mr. Alexei in this case, but having an ambiguous or an insufficient fee agreement under 1.5B was not one of them. They did bring a 1.5A to suggest that it was not a reasonable fee and then presented no evidence at the committee or the hearing level in order to show that it was an unreasonable fee. But no one's ever really discussed the things or the requirements that you are putting in your contract are insufficient. I've read a lot of case law prior to coming here for this argument today, and in almost all of the cases that I'm reading, you have attorneys who are not following the crux of Mance in taking the money without actually doing the work. So
What's your assessment, Ms. Paulding, of what the crux of Mance is? Do you think Mance does address this issue because it doesn't conclusively hold that you can't earn any of the money until all of the work is done? Or
I do not.
Do you think Mance does address this or doesn't? I guess what's your view of the crux of Mance?
I don't believe the specific issue is laid out in Mance, but I believe that the holding of Mance, which is that once the money belongs to the client until it is earned, and then there's this very crucial word of unless, which I almost read as an exception. So if I want to stop the sentence at it's the client's money until you earn it, period. Exception, you can then get informed consent to change that finding or to change that decision.
So that sounds exactly like the rule that we just heard from your opposing counsel. What's your assessment of what the rule should be if Mance doesn't clearly cover what happened here?
Well, I think actually what Mance holds is sufficient if we're willing to trust the attorneys in the DC bar to determine what the word earn means. And in all of the cases that are coming before the court on this issue, you have attorneys who are taking money and they're treating it as their own without doing any work for it. That's what Mance was. I don't necessarily thought that Mance interpreted that 15 years down the road, we were going to come up with this issue.
But counsel, I mean, I get we have to trust attorneys and they take oaths and all of that. And I don't think this case has to turn on just the most egregious cases by attorneys. I think at the end of the day, I'm not saying your client did this, but your client's hourly rate could have been $100 an hour. It could have been $500 an hour, and it could have been $1,500 an hour. We don't know. And certainly his client in the immigration matter, I've forgotten her name, didn't know, right? And so if Mr. Alexei had done 6 hours of work or 10 hours of work, whatever, let's say 10 so that I can do the math, and his hourly rate was $1,500 an hour, which his client did not know, then he would have been able to draw $15,000, right? If his hourly rate was $100, he would have only been able to draw $1,000. The client had no idea. How can that possibly be an appropriate way to write the rule?
We have no idea what this client knows. And I think that's a very important.
But it wasn't in the agreement. I mean, that's what,
True.
right?
100%. It's that particular thing is not in the agreement, but Ms. DeJomko did not list anything in her bar complaint regarding the financial aspect of the advanced fee.
No, but okay, I'm not saying that my point is not that your client's client was, what happened there is beside the point to me. We're trying to figure out the best rule to write.
Yes, sir.
And my point is that it can't just be, yes, we trust attorneys, but we can't have this rule be where the attorney dictates their own hourly rate without the client knowing that the attorney can draw down a flat fee based on that hourly rate, with the client not even knowing what the hourly rate is.
But I also don't think this is a problem, to go up with Judge Easterly's question before to disciplinary counsel. This isn't an issue. It's not coming up. You're not having people coming forward and saying, oh my goodness, he used a $300 rate or a $200 rate. That's just not a problem. The
Well,
problem.
Ms.
is
Paulding, I'm not clear what your argument is. Your argument is that there was no problem here because Mance allows this? Or there was no problem here because Mance doesn't preclude this? And
Mance-
therefore the rule should be. Could you
Mance does
answer
not-
those questions?
Mance does not preclude an attorney from drawing down on the trust account when he earns the money.
And
Yes, the
what
question
in
is-
Mance do you rely on to support that?
Oh, well, that's the holding. So the holding specifically recites Rule 1.15D, that when the attorney receives payment of a flat fee at the outset of the representation, the payment is the advance of unearned fees shall be treated as property of the client until earned, unless. But if you stop at earned, then the question becomes, do we make a hard line or a hard definition for what the word earned is? Or do we allow the attorneys to interpret that, taking their oath and being fiduciaries for their clients?
What does earned mean? And how should we read earned in order to support what you're arguing?
Well, if you're going to confer a benefit upon the client, I believe that is a definition that Mance uses in drawing from some other cases. So if you're doing.
Do you
work
need
on-
to tell the client, okay, I'm taking this flat fee. It's not mine, and you've paid it to me, but I hold it in escrow until I earn it. Right?
Yes,
Should you tell your client that?
yes.
That should be part of the rule, right? And then do you need to say what it means to earn the fee?
I don't
That-
think
that's
you have to.
exactly my question.
You-
What is your interpretation of what it means to earn the fee?
Well, I think that that's individual for every attorney. Right now, I'm earning a fee by doing an oral argument. But if you didn't request oral argument, I may be earning a fee by writing a brief or by doing research for
But
another.
if you entered into an engagement letter with your client and the agreement did not contemplate you doing an oral argument, you couldn't come to the client and say, I went and appeared before the DC Court of Appeals, I'm sorry. And
Where are we?
and so I earned those fees because the earning has to be based in some objective agreement between the client and the attorney. Otherwise, it's not earned from the
But I
client's
think-
perspective.
Well, but just to piggyback on Judge Shanker's question, there's two parts to this earn. What it means to earn, and I hear you saying perform some legal services. And then the question is when, under a flat fee agreement, is it earned? Is it earned when all agreed upon services are performed or just any of the services, some of the services? I'm not sure I'm clear on your view of that.
I believe it's after any of the services.
Based on
You could
what?
choose, well, that's the interpretation of earn. I mean, that's the legal interpretation
I
of. the
feel like we're
rule.
going in a circle.
We are going in circles, and that's because Mance, I don't think, defines what earn is. Earn for an immigration attorney will look different than earning for a criminal defense attorney will look
Right,
different.
But let me ask you, how do you respond to disciplinary counsel's argument that under a flat fee arrangement, you earned means when all the work that was agreed upon is completed?
Oh, I absolutely disagree with that. As I cited in my brief, an example where you may
Okay.
be doing a case that is protracted, that's very long.
But why? I mean, what is your rationale for disagreeing? I
Because
happen to
think
agree with you. I'm just trying to look
Sure,
for some
because it's-
support.
it's really just the plain definition of the word earn. Earn occurs when I perform a service for you and then I get something in return, whether or
That
not.
doesn't answer the question of the other interpretation that earned under the flat fee agreement means all that was bargained for must be completed before you earn any of it.
Well, that's where I think we don't have the
interpretation.
guidance. Mance does not tell us that. I think what Mance does is Mance quotes Sather and Mance quotes Hallmark and other cases in which those cases use the word to the degree that you did the work. till
How
you
would
can
you,
justify
how
your-
would you write a holding to answer this question?
I think that my holding would be very similar to Mance with an additional caveat that an attorney must be prepared to justify the drawdowns from the trust account under the belief that they've earned the money. And I
Well,
think.
wait a
that's what-
second. I mean, when we were talking a minute ago, I said, do you need to tell the client that you're holding the funds in escrow until earned?
No, and I'm not
And-
saying that has to be done in your
You-
contract.
No, as a rule by this court, would we tell lawyers, you take a flat fee, under Mance, it's not yours until earned.
Yes.
But now, in this case, we are saying you need to tell the client that you're holding the funds in escrow until they are earned. And you said yes.
Well, I believe that's in the actual rules. I don't know exactly, but where you need to.
Okay, but let's pretend like it's not. And
Okay.
so you tell the client you're holding the funds in escrow until earned. And then my next question is, do you need to explain to them what earned means to you? I mean, maybe we don't need to have a universal definition of what earned is, but do you need to tell the client, this is what that means for me in this contract, right? Judge Schenker was talking about hourly rates. That would be one way to say, if I work a certain number of hours and I charge, this rate per hour, I earn as I go, as I work these hours. I'm assuming that some lawyers who charge flat fees don't keep track of their hours and don't have hourly rates in a way that big law firms have, right? Because they just charge the flat fee, and that's kind of the point. But then I think we get to this milestone question that disciplinary counsel is proposing of, well, at least you have to break it up into chunks. And do you need to tell the client, okay, until I hold it in escrow until earned. And for me, earning means, I do my initial, interviews. That's one point at which I earn fees, and that's about a quarter of the flat fee. And then I do, some additional, I write a pleading. And that's another milestone at which I earn fees. And that takes me to about 50%. And then I, argue the case in front of whatever arbiter. And that's another chunk, right? And then everything else is me explaining to you what happened and, tying up loose ends. And that's the last quarter. Do you need to spell that out like that?
No. Absolutely not. And I think that would be almost impossible.
I
to
mean,
do.
that's under one, that would be one way of saying, but each lawyer could say how they earned the fees. I'm not saying that you would have to do that in every case, but my basic question is, do you have to tell your client how you earn the fees or at what point you earn the fees? If you're
I do
telling
not
them
think-
that you're holding it in escrow until you earn the fees, don't you need to explain what earning means in some way?
I don't think
No.
so. I think you can
You
put
don't think
that.
so?
I don't think so. You can put it in your contract. I think if your client then asks for an accounting, you should have good records that allow you to provide that accounting.
But
And
I
I
am
think that
talking
there's-
about putting it in your contract. I think we're talking past each other. I'm trying to figure out what the rule is, what the rule should be. And I thought the first premise of the rule should be that you should tell your client that you hold the funds in escrow until it is earned. And should the second part of the rule, the very general rule that can be then applied in contracts, however lawyers want to do it, you tell the client how you earn the fees. And that could be by setting an hourly rate. It could be by breaking it up into chunks and milestones, but you have to tell the client what it means to earn the fees. Do you
Well,
disagree with that?
The court can make that rule, but I think if we're making that rule, then we're going above and beyond what is in Rule 1.15E. I mean, there's nothing in that says that we have to go into that much detail. And then what it's going to turn into is just a slew of cases in front of disciplinary counsel in which we are nitpicking various fee agreements. If I just put a general line in there that as I earn the money per my discretion, I move it from the trust to the operating. Well, is that going to be sufficient, or will disciplinary counsel then say, well, Ms. Paulding, that's not specific enough? But I can't necessarily do a standard contract because every case will look different. If I'm doing a misdemeanor assault versus a felony murder case, those milestones are different. So then do we put the onus back on counsel to then change their individual fee agreement per each individual client? I just don't think that that's necessary.
Counsel, it seems to me that we are just conflating hourly rates and flat fees. And I mean, we have to start from the premise that these are two alternative options for fee arrangements between attorneys and clients. And in my mind, attorneys go to clients and say, I can charge you by the hour, or I can charge you $10,000 if and when I do X. And if you go down that second path, that's the path you've gone down. And why would a client ever think that they owe $10,000 if X wasn't done? I just, and why would they think that they had also agreed to a hybrid hourly rate when that was not the path that was gone down?
I don't necessarily think they agreed to a hybrid hourly rate. I think Mr. Alexi had to justify to the hearing committee why a certain amount of money was drawn down at that time. And that's kind of his analogy or his determination of how it was used. It's not like he went to court, so I pay $500. I went to court a second time, I paid another $500. I agree that if you are going to pay a $10,000 retainer, you should get the full 10,000 services. But
that's,
if
it's not a retainer, it's a flat fee.
Well,
Those are
a
two
flat
different
fee.
concepts.
But if you fire me, and I'm only halfway through your case on the flat fee, I believe it's rule 1.16, or we have another rule that says, well, I get to still get paid for the work that I did. So I think it's logical to believe that your attorney is going to be compensated for the work that they did, but they don't get to that full $10,000 amount unless all the work is completed, per your example. And I understand that my time has expired, but I'm still happy to answer any other questions.
So if I understand you correctly, you think 1.15E. And I guess, is there any particular part of 1.15E that you think makes this clear and therefore we don't need a further rule beyond where we are with Mance and 1.15E?
I think if you read 1.15E, which is the same as the holding in Mance, basically, the question will become, do you trust the DC attorneys and the bar?
Right. So what
to
are you
define what
referring
earned
to? Until advances of unearned fees and unincurred costs shall be treated as property of the client until earned or incurred unless the client gives informed consent to a different arrangement. That's the
Yes, ma'am.
language that you're.
That's the holding in Mance as well.
And so where does the informed consent to drawing down as services are provided and in your view earned, where does that come in to play?
I don't believe that was what the intention was. The intention in Mance was we have to tell our attorneys that they can't just keep $10,000 flat fees up front in their operating accounts. It needs to go in trust and they need to earn the money first. That was a huge change in the rule. And I think that's very clear. But I think what they're saying here is because we're making such a big change in the rule, we're going to give you an exception that if for some reason you decide that this initial payment is not going to go in your trust account, then you have to talk it through with the client under informed consent and write it down and make sure they understand that.
So
But
you
I think
interpret that as meaning only if the entire amount of the flat fee, $10,000, for example, the lawyer did not want to put it in the trust account and rather wanted to put the entire amount in their operating account. That's where the informed consent would come into play.
Well, that's
Not-
my reading of it because Mr. Mance ultimately took a good portion of that money and he put it in one account and some money in the other. And he was commingling and doing all kinds of things that he wasn't supposed to do without
Right.
Referring it
But
all with
here,
his client.
here where we're talking about, council putting the initial amount in the trust account and then making draws on the account as some services were performed. How, in your view, is that covered by 1.16?
You mean 1.15E or?
I'm sorry, 1.15E.
Okay, I do not think that 1.15E goes into that much detail to say one way or the other that you have to list what the drawdowns for trust is. What I'm saying is that in this particular case, I think 1.15E is sufficient. It's sufficient for the reasons that the board described.
Right,
It'll-
but counsel, I hope, I don't mean to be talking past you.
Yes,
I'm
ma'am.
I'm trying to better understand why you think it was sufficient, because what you just described was a scenario that we hadn't really been talking about explicitly. Was you just said if the lawyer wants to put the entire amount of the flat fee into the lawyer's operating account, that's what triggers 1.15E.
Well, no, I think what Mance wasn't talking about drawdowns from the trust account during the representation. Mance was talking about having money present when Mr. Saunders fired Mr. Mance and Mance wasn't able to pay him back because he treated that money as his own immediately. And so if you want to make another arrangement where you're saying that client's money is not it's not their own money at the outset, I think you need to put that in writing. And I think that's what the unless stands for. I don't think it specifically gives guidance.
I guess I'm not
whether-
following you completely, counsel.
Sure.
For the situation that we are confronted with here,
Yes.
where Mr. Vital, I'm sorry, I've got
Alexei.
counsel's name wrong, where counsel deposited the flat fee into the client's account and then performed some of the work or earned some of the work, depending how you interpret that, and then drew down some of the fee. Was informed consent needed for that arrangement? In your
I don't
view?
think so. I think if she gave him the first $2,500 and he wanted to put it in his operating account for some reason, they would have to have a conversation about that and acknowledge that she understood what that meant and why that was happening. And that obviously wasn't the facts of this case.
Counsel, I just wanted to ask for clarification. You've been talking about 1.5E. Is that correct?
1.15E.
15E. Okay, thank you.
Sorry.
Sorry, I don't know if either of my colleagues have any further questions?
No.
All right.
Thank you very much.
Thank you, counsel. All right,
Thank you.
thank you.
So with my time, I would like to just make the case as to,
Full 15 minutes. You giving
I
you a
can go that
couple of
long.
minutes for rebuttal, yes, thank you.
so I'd like to make the case that if you think that Mance didn't establish the rule, why the rule that we've advocated in our brief is the right one. We are a self-regulating profession and we expect lawyers to comply with the rules. But it would not be wouldn't be a reasonable thing for a self-regulating profession to say, we trust attorneys to do the right thing with clients' money. And we don't
Counsel,
look behind what they.
Can I interrupt briefly just to ask you to comment on Ms. Paulding's interpretation of Mance based on Rule 1.15E? That it really only, that Mance really only applied to situations where counsel was seeking to put the entire flat fee into counsel's operating account as opposed to putting it in trust until monies were earned.
Sure. So Mance absolutely did address that. And the rule, or at least the practice before Mance was that attorneys would do that. They would tell the clients that it was earned. But in deciding that that was not in accordance with the rules, the court described what would be in accordance with the rules. And so it said, look, if you're paying for the flat fee, you're going down, as Judge Shanker says, that road, and you are going to have to complete all of the services. And then it said, but we understand this might be a problem. So here's what you can do in the alternative. In the alternative, you tell the client, what your milestones are going to be, or, you know, anything, any reasonable basis. And it's going to be different. The attorney knows best what the milestones might be. And I should point out that this actually was, this engagement was broken up into many chunks of flat fees. There was one fee for filing the first form. There was a smaller fee for the second one, and a larger fee for an appeal. So it's not like the attorneys don't have this in mind, but if you're going to crack the rule, I think it should include three things. One is you need to, the overall question is that the attorney's ability to pay himself from money that the client has paid needs to be in the agreement, right? The agreement has to control that. It should say how it's going to be earned, whether it's by milestones or hourly or some other, you know, the passage of time. We think this is going to take 6 months, and after 3 months, I'll take X amount. That needs to control. It needs to be in the agreement. But I think the court should also say what happens if the attorney doesn't do that. What's the rule to apply if the attorney just says, this is a flat fee and it's going to cover 5 years worth of work and it's, you know, $50,000. Like, if he doesn't say anything else, he should be stuck with that agreement, and he should apply to it, and he should, you know, adhere to it. And if he doesn't, there would be a consequence. And the third thing is that in setting out the rules, you keep in mind the interests of the clients that the court considered in Mance. The client needs to be have the ability to change their attorney in the middle of the engagement. If they decide the attorney's not doing what they want, the money shouldn't be gone without any notice to them, without them knowing, or without any information as to when or why the attorney took it. And they also need the ability to reasonably challenge the fee. If the attorney can take it without telling them, without documenting anything, that is gone. And I just point out that it's very clear under the court's cases that if there's a challenge, the attorney has to keep that money in trust. So, you know, it's taking away the client's ability to have that challenge and to preserve that money during the challenge. If you, you know, as my friend says, just put this to the attorney's discretion. And I think that was 3, and I think I said.
Counsel, can I ask you a quick question, and possibly in the interest of time, propose what might be your answer to me and see if you agree with that answer. So your colleague on the other side mentioned 1.16D, which talks about refunding advance payments upon termination of representation of any expense that has not been earned or incurred. And the suggestion is that this cuts against, I guess, the reading of 1.15E that suggests that, well, I guess, is your answer that this just begs the question of when something is earned, and if it hasn't been earned, then it need not be refunded? Although the rule uses the word incurred too.
Right. So I think incurred is referring to expenses, and there's not usually very much dispute about that. You paid a filing fee, you know, you can reimburse yourself for the filing fee. So
Can you do that immediately, or you have to wait till the end to reimburse yourself for fees too?
So I mean, this actually I think is not a problem when attorneys charge, and Mr. Alexi charged separately for filing fees. They tend to put that in, and they're very clear about it. And so that was part of the agreement here, and we wouldn't challenge what. Actually, now I'm questioning myself whether this was in there, but I think it was in there.
So they could earn the fees
You can
as they're
incur the
incurred
fee.
you
know, you can incur a cost, yes. Then, and I think the attorney doesn't have to wait till the end of the representation to reimburse themselves from the trust account for incurred expenses. But as to the fee, I think the fee agreement has to control. And I do think the court should say what happens if the attorney doesn't say. What is the default rule? If
Right.
not
So your answer is this still turns on what we mean by earned in 1.5,
yes.
1.15E as well as 1.16D.
Yes, so the, what happens with the 1.5, the one about returning funds, is that they hold it over without a basis, and there might be a dispute, or sometimes there's no dispute, and they just unreasonably decide to withhold it. But if their basis is that I earned it, that really is going to should go back to the agreement and how it is earned. And for that, we need to, the agreement should control, but we also need to know what happens if the agreement doesn't say.
Right, but if the agreement doesn't say, and it's a flat fee, then your answer would be they hadn't earned it under 1.16D and would not have to
Right.
return it,
So
or would not.
then you go
be
to the
entitled.
quantum merit. It's now they might say, I think in that situation, you would have an attorney say, look, you're leaving me in the lurch. I've earned half the fee. I'm going to give you back the other half, but I'm keeping the first half, and maybe the client agrees or maybe not. And if the client doesn't agree, they would have to hold that in trust until that's resolved, which it could be by the attorney arbitration board and so forth. But yes, at base, it would turn on, it still goes back to whether it's earned, and like whether it's under the agreement, whether it's under some sort of default rule, or in the case of the middle of a representation, a sort of quantum merit type basis. If, again, assuming it's not in the agreement. If there are no further questions, we ask the court to find that there was misappropriation in this case and impose the rule as we've discussed.
All right, thank you, Mr. Meltzer and Ms. Paulding. Thank you both for your arguments and for your briefs. And that concludes our arguments for today.
Thank you, Your Honor.
Thank you.
All right. This honorable court is now adjourned. Okay, thank you,